Welcome to the Hotel Investors Marketplace produced by Hotel Brokers International. I'm Brant Niehaus, Vice President of HBI and President of Huff Niehaus & Associates, Inc., a hotel brokerage and consulting firm located in Louisville, Kentucky. The Hotel Investors Marketplace today is designed to provide today's hotel owners and investors with the most current industry information and an opportunity to review recently listed hotels. We are looking at a few of those hotels that are available as I do this introduction. While everyone is getting signed in and comfortable, we will highlight these members' listings and share with you a few details about HBI and housekeeping for today. Hotel Brokers International was founded in 1959 and is the leading hotel sales organization with a membership of more than 50 hotel broker specialists. HBI members have successfully negotiated more than 10,000 hotel real estate transactions and annually account for approximately 48% of all mid-market and economy hotel sales in the United States. You can visit HBI on the web at hbihotels.com. If at any time during the webcast you have a question, just click on the Ask Question button found on the gray bar located at the top of the webcast player. Type in your question and submit it. We will answer as many as our time allows. We want you to know that we are doing what we are. Excuse me. We want you to let us know what we are doing today and how we are doing. So please rate the webcast by clicking on the rate, which is found on the gray bar located at the top of the webcast player. Later today, this webcast will be posted for on-demand viewing at hbihotels.com. Today, I have the pleasure of welcoming Clifford Davidson to our webcast. Cliff is an attorney with Sussman Shank, LLP, in Portland, Oregon. As a commercial litigator with jury trial experience, Cliff has focused on commercial contract disputes, entertainment and intellectual property litigation, First Amendment litigation, counseling in the areas of privacy and data security, and insurance coverage. Welcome, Cliff. I'll turn it over to you, and I'll only interrupt if we have some questions.
Thanks very much. Hello, everyone, and thank you so much for having me here. So as you heard, I'm in Portland, Oregon. So my focus is in particular on the law in the Ninth Circuit, which covers a number of states, including California, Oregon, Washington, Alaska, Hawaii, Arizona. I'm going to try to give some examples from across the country, but sort of to the extent I talk about cases that involve online reviews, they're mostly going to be from my neck of the woods, although the principles in them are kind of generally applicable. So the title of this presentation, as you can see, is Yelp Help, Dealing with Online Reviews. I'm not claiming to address every aspect of this topic because it's a fairly large one, as you might know from news coverage of online reviews or lawsuits that you've heard about throughout the country concerning reviews of hotels or other hospitality industry venues. But what I want to do is sort of give you a general overview of some of the legal principles that apply to responding or not responding to online reviews, so that when you sort of undertake efforts to address these issues or formulate strategies for addressing online reviews in your own companies, you kind of know sort of a background of what's at play, what has worked in the past, what has gone poorly, and we're certainly going to go over some of those examples. And you can think a little bit more broadly about these issues. So I'd like to start with a column that was in the New York Times on October 10th of this year. It's a column called The Ethicist, where readers will write in and ask sort of ethics type questions to this columnist. And this one I think is particularly applicable to this topic. It said, I recently spent, this was what the person wrote in, I recently spent several days at a relatively expensive hotel. The place was deplorable and unsanitary, with an unresponsive front desk. I gave it a poor write-up on TripAdvisor.com, the travel website, titling my review an overpriced dung heap. The following day, the owner contacted me through the site with an offer to refund almost half the cost of my stay if I would retract my review. I accepted the handsome offer and deleted my post. Who was the most unethical, me for accepting the bribe, the owner for offering it, or the site, which enables this chicanery and therefore has untrustworthy reviews? This was submitted by a man in Florida. So here's what the ethicist said. In this case, I'd classify the hotel owner as the least ethical actor, but you, the guy who wrote in, are a close second. TripAdvisor has clear guidelines regarding what business owners can and cannot do about bad reviews, most notably the following. Quote, owners may not ask reviewers to remove a review, unquote, using the TripAdvisor messaging system. Of course, I'm not sure how this slide just advanced, one second. Of course, this is not legally binding, and even if it were, there are many other ways an owner could contact a reviewer. Moreover, TripAdvisor has almost no editorial control over the veracity of the reviews it hosts, all of which are written by unvetted writers beholden to nobody. The site can't necessarily be trusted, and anyone using it has a responsibility to realize that. So I would say TripAdvisor's ethical breach is the least troubling. Your decision to remove a review upon the acceptance of a bribe was lame, which you clearly understand. If you were a professional newspaper critic, such behavior would be grounds for termination. You, however, are just an annoyed guy who wrote a free review. I can't accurately gauge the depth of your ethical malfunction because I don't know what your original goal was. If your motive for writing the review was to altruistically warn other travelers, it would seem your integrity has a pretty low price tag. Then maybe your true motive was to mock the hotel. Maybe you simply wanted to vent your displeasure in public or to entertain the kind of weirdo who enjoys reading over-the-top TripAdvisor takedowns. Maybe you wrote it hoping you would get a refund. Regardless, you're an unreliable narrator with no critical credibility. But the hotel owner is unequivocally unethical. For one thing, he's ignoring the rules established by TripAdvisor. Granted, he may never have agreed to those policies in the first place, but he's choosing to involve himself with the site and interfering with a process in which the goal, at least in theory, is consumer transparency. He also did not offer a reimbursement as a way to satisfy a customer, but only in exchange for the removal of an honest assessment of his hotel. If this is his normal business practice, it's almost as if he's involved with reverse marketing. He overcharges for a bad experience and only offers a rebate to those who inform strangers that this is how he operates. So I think that this piece kind of frames nicely a lot of the concerns surrounding responses to online reviews, and it also shows that this is an issue that, the New York Times will take up as of 2 months ago, but is on a lot of people's minds. And even as recently as end of November of this year, there was an article on CNN about an inn in England that the headline is "Guests Fined for Leaving Review of Filthy, Dirty, Rotten Hotel" on TripAdvisor. And there's some interesting aspects of this review that I'm going to talk about later, but what they wrote was, the wallpaper was peeling off the walls, the carpet was thin, dirty, and stained. The bed was something else. It must have come out of the ark. The base was all scuffed and dirty, and the springs in the mattress attacked you in the night. And so when these guests left this review, the hotel turned around and fined them £100, which is about $150. And that was reversed eventually because some authorities got involved in whatever town this was in England. But the interesting aspects of the review, I think, are sort of this alternating between opinion and fact, and that's key in the U.S. for defamation law. So, for example, when he said the wallpaper was peeling off the walls, that's a fairly factual statement. But then when he says the bed was something else, it must have come out of the ark, I assume that means Noah's Ark, then that's clearly opinion. I don't think he's seriously claiming that the bed actually came from Noah's Ark. So And then when it says, and the springs in the mattress attacked you in the night, that seems to be another opinion statement, although one that's based on an underlying fact. And we'll get to that in a second, that if you make an opinion statement that seems to be based on a fact that you're not necessarily telling the reader, that can be actionable in defamation, which is the primary law that applies to online reviews. So anyway, that's just sort of a basic introduction to the problem. I'd now like to talk a little bit about sort of the use of online reviews. There was a study that Nielsen did in 2013 for Yelp. So, you know, it's sort of biased in their favor, and Yelp is paying for it, so take it for what you will. But as of 2013, there were 11 million monthly users of Yelp's mobile app. They surveyed about 1,415 people. I'm not quite sure how they chose those people, but they said that of that group, 85% of the consumers found their local business information online. 51% of respondents make their purchase decisions after reviewing Yelp. 70% of Yelp users surveyed found online opinions somewhat or completely trustworthy. I'm not quite sure how they reached that conclusion, but apparently that's what they said. And 42% stated that they were searching for businesses in the hotels and travel category. So that's of particular relevance to the conversation today. If you want to see the more complete results, if you just Google Nielsen survey and Yelp, you can find these more complete results. So I'm not going to go through the entire thing. It's several pages long. And this, I think, is a significant response. The question was, please rank the following factors you might consider when researching a local business on Yelp based on their importance to you. So 44% of people who responded to the survey said that they based it on the text of the review as opposed to sort of the star rating, which doesn't tell you much. It just kind of is people's general feeling of the place. But 44% said that the text was important. 26% said the rating itself, like, you know, star rating 1 through 5. 17% said the number of reviews, and 14% said reviews from friends or family. I'm not sure if that means, and Nielsen didn't explain this, I'm not sure if that means directly from family members or if it means reviews that friends and family left on these sites. It's not clear. But anyway, that sort of gives you a sense that people are actually reading review text and taking it reasonably seriously, whether they ought to or not. So at this point, I'd like to ask a couple of questions. First, in the past 3 months, please vote yes or no. Have you posted an online review of a business? All right, so 75% of you said yes, 25% of you said no. And of those of you who posted reviews in the past 6 months, have more of them been positive or negative? Interesting. Okay, so 80% of you said that more have been positive. 20% said more have been negative. So you're all a bunch of nice people. So good job. And finally, have you ever responded to an online review, either personally or on behalf of a business? All right, so 75% of you have not responded to an online review. 25% of you have. All right, so I was just asking those questions to get a sense of some topics that I want to address. So here's some things I want to go over in this presentation. The first is just a general introduction to defamation law, some of the things that you should keep in mind when you're thinking about whether you really need to take legal action against someone who's posted a review. Part two is sort of the pitfalls of litigating based on defamation, and for that I'm going to talk about some of the both legal and non-legal implications of suing someone. And finally, I'm going to discuss some ways of addressing online reviews short of actually litigating, and also provide some examples of ways people have tried to address online reviews but have just failed miserably. So I will start off with defamation law. So the basics of defamation law and when you can sue someone based on something that they say is rooted in the First Amendment to the Federal Constitution, which says, among other things, Congress shall make no law abridging the freedom of speech or of the press. And you know, that was a large break from the British tradition, which was a lot more restrictive. And as I'll explain later, if you insulted someone, whether or not it was true, you could sue for it, and whether or not it was opinion. So we'll discuss that in a second. And then there are state constitutions as well that have free speech clauses. So the Oregon Constitution, which is similar to the Washington, New Jersey, Indiana, Colorado, and Alaska constitutions, at least with respect to free speech, says no law shall be passed restraining the free expression of opinion or restricting the right to speak, write, or print freely on any subject whatever, and here's the important part, but every person shall be responsible for the abuse of this right. You don't see any language like that in the federal constitution, but you do see that in state constitutions, and most states have something like that in there. I was just quoting a few examples. And that's sort of the basis for being able to sue people based on defamation, on untrue statements of fact that damage reputation. So these free speech clauses cover not just actions by the legislature, not just the creation of laws, and not just executive actions such as the enforcement of laws or, you know, if the police break up a protest or something like that, that's an executive action that can affect speech. But it also affects judicial action, which means private lawsuits. So if you sue somebody, essentially what these are saying is that the court can't hold someone liable for certain speech acts. Or conversely, people can be held liable for abusing their right to free speech by speaking falsehoods that damage reputation. Now, as I mentioned, the law used to be very different here, and it's kind of important to just know this. I mean, there's no immediate application of it, but just as a historical background, when you're thinking of is this opinion or not, and can I go after someone for posting this review or not? The law in England, going all the way back to 1275, was this doctrine called Scandalous Magnatum, which basically said you can't say anything scandalous about the king or about royalty or basically about important people. And the irony, at least compared to U.S. law, was that the more important the person, the less insulting thing you could say about them. We have the opposite, and I'll talk about that in a second, but now, if you say something insulting about a public figure, unless you know it to be false, that public figure can't sue you. But if you say it about a private person, then it's a much lower standard. If you don't even have to mean to insult them, and you don't even have to have any idea as to whether it's true. If it turns out to be false, you can be liable for it. So that's a big difference. So it was all about reputation. It didn't matter if it was true. I mean, there were cases on this from the 1600s saying like, yeah, we understand that the statement's true, but it's insulting and it doesn't matter. You don't get to say it. All that you had, the only requirements were that a third party heard the statement, that third party understood that it was insulting to the person that was discussed, and that someone would understand that it was about that person. And sort of the main motivation for libel and defamation laws was really public order, because apparently at one point there were so many duels, you know, I don't know, with the white gloves slapping or swords or something like that, where Parliament said that they needed to step in and put a stop to it. So they actually criminalized libel, saying that if you insulted someone and their reputation, didn't matter if it was true, just as a matter of preserving order, we're going to allow people to sue for that rather than, you know, stabbing each other with swords or whatever it was that they did. So that's sort of the tradition that we came from. But that's not the law that we've chosen. So this British law, which is known here now as the common law, has been limited by the First Amendment and the state constitutions that we went over. And you know, I'm not going to review all of the cases because it's been, you know, quite a bit of development. But the basic elements of defamation are these. One, it has to be false. I'll get to that in a second. Two, it can't be a privileged communication. Three, there may have to be a certain level of fault of the person who's making the statement. And four, you may or may not have to prove damages. So I'm going to go through each of these elements one by one. So the first one, falsity. Contrary to what I was saying about British law, the statement has to be demonstrably false in order to be actionable. If you simply express an opinion is something that can't really be proven false or true. It's your view of something, and yeah, it may turn out that your opinion is wrong, but the expression of opinion is considered the most protected category of speech in the U.S. because the theory is if you express an opinion about the government or you express an opinion about a public figure, that's necessary for political discourse. And so the courts are going to protect that the most. So if someone leaves an online review, for example, you know, oh, this place is the worst. Well, you can't really show that that's false. I mean, because in that person's view, it's the worst. So that's just sort of an example. Second, it's not made in specific circumstances that we can consider to be privileged. And this is important for something I'm going to address later in the presentation. But if you are making a statement in a legislative proceeding, or you make a statement to a court, or you make a statement to, say you're an employer giving a recommendation or not about one of your former employees, all of those have various levels of protection that we accord to them. We call that either partial immunity or complete immunity with respect to those statements. So if you say something in court and in the context of a case that you have, you can't be sued based on your representations to the court, unless you're doing it in completely bad faith and there's no basis for it, and that's a whole other issue, and you can be sued for malicious prosecution. But someone can't sue you for defamation simply because you insult them somehow in the course of a court proceeding. So that's what I mean by it's not a privileged communication. It's not made in one of those circumstances. Three, the element of fault. Under some circumstances, for example, a public figure suing a newspaper or a public figure suing a blogger or something like that, because the person is considered of general notoriety, that's someone who's putting themselves out there. And when you put yourself out there like that, you should expect people to comment on you. And so therefore, before someone in that position, before a public figure like that can sue for defamation, they have to show that the person knew that the statement was false, but they said it anyway. I'll discuss other situations where that higher level of fault applies, but it can range anywhere from no fault whatsoever, someone just said something that was untrue and it caused you damage, to knowingly false or recklessly disregarding the fact that it would be false. And finally, damages is a very important aspect of this, because if someone insults or defames a private person and says, oh, he stole from his last employer, right? That's a very damaging statement. And for that kind of a thing, it's what we call defamation per se on its own. You don't have to prove that there was any damage. It's presumed that you're going to be damaged from then on in trying to find another job or pursue a profession or get some sort of license that you might need. But in other situations, we are going to make people prove that they were damaged in some respect, and that can apply in the context of businesses that are sued based on the quality of their products. So that's an important element that we're going to discuss at some point. I just want to pause really quick. If anyone has any questions, please feel free to indicate that. Otherwise, I'm going to sort of move on. All right, I don't see any. So here's a deep thought to consider, and my apologies to Saturday Night Live for the Jack Handey reference. But here's what the Supreme Court said in 1966, or at least one of the justices said. It said, defamation reflects no more than our basic concept of the essential dignity and worth of every human being, a concept at the root of any decent system of ordered liberty. Now, in that case, which is Rosenblatt v. Baer, the Supreme Court was talking about defamation of a person, of an individual who's being insulted and is going to take it personally, and people are going to regard that person, as the court would say, with opprobrium, with, disfavorably, right? But what happens in the context that we're sort of more focused on here, which is when someone says these kinds of things about a business rather than an individual? And just to clarify, there have been, in the news over the past couple of years, there's been discussion about, our company's people, our corporation's people, things like that. That's not really what I'm getting at. That doesn't really necessarily apply to this situation that the court was considering for those cases. What we're more saying is, can a business be treated like a person in terms of having an inherent, for lack of a better term, an inherent dignity that can be insulted? And sort of what does that look like? Because that's kind of at the heart of what you can do to respond to an online review. So when someone is talking about the quality of a good or a service, we're talking about something it's called trade libel. It can also be called commercial disparagement in some cases. It's the intentional disparagement of quality that results in pecuniary damage to the plaintiff. So if we unpack that a little bit, you'll see the word intentional. That goes back to the elements that I was discussing a little bit earlier. It means that someone actually has to mean to insult the good or the business. And the plaintiff, so normally truth is a defense that, if someone is sued for defamation, they can they can say, oh, but my statement was true, and then that's an issue that the jury can decide, or whoever the finder of fact is. It could be a judge. But here, when you're talking about a business suing for having its goods or reputation sullied, the business has to show that the statement was false. So sort of the flip side of that. And the plaintiff has to show that it was knowingly false. And, as I said, I'm talking, some people have joined since the beginning of this presentation. I'm talking in generalities. Some states might vary, but this is the case in most states. When you're talking about commercial disparagement or trade libel, the plaintiff has to show falsity, and the plaintiff has to show knowing falsity, and you have to show damages. So if you remember my example, you know, a statement that someone stole from their previous employer, right? That's a statement about an individual. It's presumed that that's going to harm them when they look for other jobs. But here, there is no such presumption. A business has to show that they've been damaged, and they have to show that there's a link between the statement and the damages they suffered. So that's a really hard thing to do in tort law, because, for example, a company's sales might have dropped off anyway, just due to cyclical nature of the lodging industry, or something like that, just as an example. So you have to show that it dropped off because of the statement, which is a fairly high burden. And just sort of to understand this concept a little bit more fully, I want to give two examples. The first is a case from 1971 in Washington. Here's what the court said about a situation where, on one hand, it's a statement about a business, but on the other hand, it's also a statement about the people who run the business. And I think that this is of great application in the hospitality context, because you might have beds and breakfasts or smaller places that are run by a family or just a few people. And I'm going to give you a few examples of this, but this is from 1971 in Washington. They said, it's the rule that where a statement only disparages the quality of goods, the statement is actionable if special damages are pleaded and proved. So they're talking about the damages element of this. Then they say, on the other hand, it is the rule that defamatory words spoken of a person, which in themselves prejudice him in his profession, trade, vocation, or office, are slanderous and actionable per se, meaning without a proof of damages, unless they are either true or privileged. And here's how they unify these two. A statement may be published in circumstances that violate both of the just cited rules. That is, it may disparage the quality of the product and at the same time imply the owner or vendor is dishonest, fraudulent, or incompetent, thus affecting the owner or vendor's business reputation. In such circumstances, an action may be brought for defamation as well as for disparagement. So defamation is the individual tort specific to those people who are closely associated with the business. And disparagement is the action that the business itself would bring for defaming the quality of its goods. And there's a very recent example of a case like this. This was actually filed in Oregon, although it received a fair amount of national attention because it's one of the few sort of large examples of a fairly public lawsuit by a hotel or, I guess, other business against an online reviewer. So this was filed in May by a company called the Lincoln City Lodging, which owns a hotel in Lincoln City, Oregon. And the hotel is called the Ashley Inn. That's why I have that name on there, and that's just kind of how I know the case. But here was the review. So the title of the review, this was posted in April 2014. The title of the review was Nasty. And the review was this: this hotel is horrible. I will never stay there ever. The breakfast is nasty. The rooms are nasty. It appears there is no management or a very weak one. Hallway talk. The owner smokes weed. Laundry and housekeeping are either high or drunk, to include the head housekeeper. Jen, front desk, had phone sex with someone. Seriously, what kind of place is this other than just damn right nasty? What a waste of my money. Beware, people. And it was posted by someone allegedly in Prescott, Arizona, although I'll discuss in a moment that that might not actually be the case. So that's a fairly egregious example of a review that on one hand discusses the hotel, but also very explicitly alleges things about the owners of the hotel and the people who work there. And this hotel actually ended up filing a lawsuit in Multnomah County, which is where Portland's located, for both defaming the owners of the hotel and the hotel itself. Now, I'm going to come back to this case later when discussing a few of things to consider when filing a lawsuit and what some of the downsides might be. But I just wanted to provide that example to sort of give you something real to think about. And another component of this, in terms of talking about a company, is that very recently the Ninth Circuit Court of Appeals joined basically every other circuit, federal judicial circuit in the country, in saying that two things, I guess, of significance. The first is that a business review is actually an issue of public concern. So it's entitled to a higher level of protection. So if someone is speaking on an issue of public concern, the plaintiff, so let's take an example of a blogger, because that was the example in this case. There's a blogger who wrote a review of a business and its principal, right? That was the fact pattern in Obsidian Finance Group versus Crystal Cox, which is what I've cited on the slide. There was a blogger wrote a review of a business, and the Ninth Circuit Court of Appeals said that the business had to show that at the very least the blogger was negligent as to the truth of her statements. So she didn't exercise care in making those statements, which is sort of a nebulous standard, and it's the standard that applies in most tort cases when you're just talking about an unintentional act. You know, someone slips and falls and sues for negligence. This is sort of that level of stuff. But second, the court also said that a blog entry or a blog in general is to be treated like any other newspaper or publication or something else that under the First Amendment gets some leeway to publish things, and as a result, if the business is damaged and they're going to sue for defamation, they have to actually show damages. It's that higher standard I was talking about, where they have to show that the statement actually resulted in diminished business. And this is all very recent, both the Ashley N case and the Obsidian Finance case. So this is sort of a developing area, but I wanted to at least mention it. So there are a few things. I guess we're in the pitfalls of defamation litigation section of the presentation. And you might be wondering why there's a giant picture of Barbra Streisand on my slide. I actually don't really like her voice very much, but this is actually relevant, so just stick with it. There is this phenomenon called the Streisand effect, which is a term, and this picture is relevant. Don't worry, I'll get to it. It's a phenomenon that some people in the media coined a couple of years ago to describe sort of this situation. All right, Barbra Streisand has a large house, as you can see in this photo, on the coast of California. In 2002 and 2003, there were some photographers who were taking pictures of the California coastline as part of a project to document coastal erosion, which is an issue in California and many other coastal states, including Oregon, Washington, everyone. As part of that collection of photographs of the coastline, they took a picture of Barbra Streisand's mansion, which is considerable and very expensive. She thought that this was an invasion of her privacy. So she had her lawyer send letters to the photographer saying, take this down, remove the photograph. And they said, no, it's a collection of photographs of the coast. We're entitled to photograph the coast of California. Too bad. So she ends up suing. Here's what happened. There had been, up to that point when the lawsuit was filed, there had been 6 hits total on that photograph, which was posted online as part of this database of photographs of the coast. So 6 people had viewed it, or it had been viewed 6 times. As soon as she filed her lawsuit, suddenly 420,000 people per month were viewing that photograph. And so that phenomenon has now been termed the Streisand effect, which is in an effort to suppress something or an effort to have it removed, you're actually drawing much more attention to it. And I think you can see where I'm going with this. This is a huge, it's a huge downside to suing for defamation, because all you do, especially when it's related to something online, all you do is draw more attention to the statement. So you have to make sure that it's really worth it before you draw further attention to people. And if you're talking about things that are online, you know, assume that whenever you send a cease and desist letter, it's going to get posted to the internet. You know, a lot of these things are probably things that you've thought about, but it's I just want to make sure that that's in your head when you're considering whether it's worth actually pursuing legal remedies. So here's another pitfall of defamation litigation. Let's say that you sue TripAdvisor, but you don't know the real identity of the poster, and you don't know where they're located, so you don't know where you should sue, and you don't know how to serve them with legal papers or anything like that. So what you do is you file a lawsuit in your hometown, and then you serve a subpoena on TripAdvisor to find out where the poster was located. Well, this is what happened in the Ashley Inn case, which is the one in Lincoln City, Oregon. And the hotel, this ruling actually came out a couple of weeks ago. The hotel was unsuccessful in compelling TripAdvisor to reveal the identity of the poster because, and you might recall what I said earlier about sort of blogs being regarded at the same level as newspapers or other media figures. What the court said was Oregon has a media shield law, and I'm not going to read it to you, but it's on your screen right now, that protects the sources of information conveyed by media outlets. And based in part on that Ninth Circuit opinion that I read to you, it's not binding, it's federal law, this is a state case, but you know, the court needs to follow its guidance in some respects. That based on that, the TripAdvisor should be viewed as a media outlet, and therefore it doesn't have to reveal the source of the posting. So, you know, it's not clear at this point how Ashley Inn wants to proceed. I haven't checked the docket this week, so I'm not sure if anything else has been filed, but they haven't appealed from this. I'm not sure where they plan to go with it. So that's another thing you have to think about, is you might not actually be able to get the identity of the person who posted because various states have degrees of this kind of a law that shields sources for the media. And plus, even if they didn't have that law, the First Amendment protects certain aspects of anonymous speech that might make it very difficult to get a hold of the people who posted it. Now, if you know who posted it, or they're honest about it, or there are other ways of getting the information, then you don't necessarily have to worry about this. But this is one also major pitfall of defamation litigation based on online reviews. Okay, and this is another big one. And it's an issue in about 20 states in addition to California, Washington, and Oregon. But these are called anti-SLAPP laws. And SLAPP stands for Strategic Litigation Against Public Participation, which seems like a really unwieldy acronym because it is. But what it's getting at is, the reason these laws were passed or started to be passed in the late 90s, early 2000s was that state legislatures were asking people to come in and discuss practices of some corporations in the employment context or in the environmental context, basically sort of whistleblowing type hearings. And in a number of instances, before witnesses could show up for these hearings, the companies would either actually file suit or threaten suit for defamation against these witnesses, saying, if you go and testify before the legislature, we're going to sue you for all the lies that you're going to tell about our company. And so people would just stop showing up for the hearings. And the legislature, as you might imagine, was not happy with that. And so they passed this law where basically, here's how it works. If you sue somebody based on their First Amendment conduct, so in this, for purposes of this presentation, let's say that it's an online review, which is undoubtedly, an act of expression, right? So, and they're posting it in a public forum and, sort of all the trappings of First Amendment stuff. If you sue someone based on that, then, and it's a matter of public concern, and, based on the cases I discussed before, a business review can be, then that defendant can file a motion which requires you at a very early stage of litigation to explain why you have a case, to put on evidence that you have. And that's not something that you normally have to do in a lawsuit. You can file your complaint. You can take depositions. You can get documents from the other side. You can sort of prove it up. You just have to have a good faith basis to file your initial lawsuit. But for this, it actually shifts the burden to you to prove that you have some basic facts to prove your case. And that can actually be more difficult than you think, because it has to be admissible evidence, and it has to be testimony or documents, other things like that. And if you don't prove your case, then your complaint is dismissed, and the consequences can be significant. So in California and Oregon, the consequence is you have to pay the other side's attorney's fees. In Washington, it's both you have to pay the attorney's fees and there's a penalty of $10,000. Now, if the flip side is if the other side files a frivolous anti-SLAPP motion, you can get your fees from them. But first of all, if we're talking about an individual, there's no guarantee necessarily that they're even going to have the money for that. But second, it's rarely a motion for a frivolous anti-SLAPP motion is fairly rare, and judges don't grant it that often. So this is a large thing to be concerned about, and this shouldn't convince you that you should never sue for defamation. It's just that you have to have your ducks in a row before you do it, and you have to load up your complaint with as many facts as possible to show the other side that, look, if you file an anti-SLAPP motion, you're going to lose it. And furthermore, it might be frivolous if you do. And it's a very fact-dependent situation, and a very good situation where you might want to get a lawyer involved who knows anti-SLAPP law so that you don't run afoul of it and don't get yourself into this situation. So a fairly good example of the right way to approach suing for defamation for an online review is another Oregon case. I think you see a pattern emerging. It's called Neumann versus Lillis. It's about a hotel called I want to get this right, the Dancing Deer Mountain Inn. And Dancing Deer Mountain is largely a wedding venue. They have other kinds of events, but that's sort of their bread and butter. And there was a review by a guest, I think it was posted to Google, where, let's see, I want to read you this just because it gives you a nice sense of this. So it says, in the review, the defendant characterized the venue as a disaster, and Neumann as two-faced, crooked, and rude to multiple guests. He stated further that Neumann and her husband changed the rules as they saw fit by informing guests that they needed to leave the premises earlier than they had originally been told, and that Neumann would find a way to retain any security deposit and charge even more money for use of the facility. So that's pretty damning if what you do is you put on these events and then suddenly someone's putting a review saying that you changed the terms and mess things up for them. So the inn sued them. And in response to the lawsuit, the defendants who had posted this filed an anti-SLAPP motion saying, you know, exactly what I've gone over. This is a First Amendment. I have a First Amendment right to post this, and you need to put on evidence showing that you actually have a case. Well, that's exactly what the inn did. Is they, you know, this was a fortunate situation for them where they actually had witnesses who were there and who were willing to submit declarations under penalty of perjury saying, no, here's what actually happened. They didn't change the rules. Everyone went home when they were supposed to. And, you know, basically the posting was a lie. And the Court of Appeal agreed that on that record, the anti-SLAPP motion that the trial court had entered should be reversed, that it should not have been entered at all, and that the inn was not on the hook for attorney's fees because they had proven just the minimal amount of a case that they needed by having people who were there submitting declarations. So there is some hope. You just have to have, as I said, your ducks in a row, and you need to be working with an attorney who understands kind of how that works. In California, by the way, anti-SLAPP cases are rampant. I mean, it's a very widely used statute, but in other states it's not. That's definitely true in Oregon. They're becoming a little more popular in Washington, and you know, throughout the country, people are sort of realizing that they might be applicable, but it's still not nearly the level of use as in California. So, now that I've sort of gone through how it can be dangerous to sue for defamation, I want to talk about some ways to address online reviews without litigation. And, you know, this isn't going to be comprehensive. You all are the business people. You have a better sense of sort of what works for you and your business. But I want to just sort of touch on some points that you can keep in mind. So this I sort of addressed before through the ethicist piece that I read, that, you know, offering a rebate or a discount for a retraction, first of all, can violate the terms of use depending on what site we're discussing. But, you know, for Yelp or TripAdvisor, you know, they prohibit that. It also, I mean, this is sort of extreme, but it's kind of like the we don't negotiate with terrorists kind of attitude, where you don't want to reward people for or encourage people to post negative reviews. Maybe some private communication, but again, that can violate terms of use, and you know, you run the risk of sort of going down that road. So here's what you really shouldn't do. Don't fine your guests for negative reviews. I told you about the British Inn sort of at the beginning of this presentation, but sort of a more local example, page 6, you know, from the New York Post ran, and for some reason I don't have the date on this, but it was from this year. The headline is "Hotel Fines $500 for Every Bad Review Posted Online." And this is a guest house in the Catskills that I won't name, but they charged $500, or did anyway at the time this happened, $500 for every bad review posted online by guests. And here's what was in their online policy. Please know that despite the fact that wedding couples love Hudson and are in, your friends and families may not. If you have booked the inn for a wedding or other type of event and given us a deposit of any kind, there will be a $500 fine that will be deducted from your deposit for every negative review placed on any internet site by anyone in your party. But apparently if you took down the review, then you get the money back. This did not go over well on the internet, so, you know, as soon as people found out about it, it got around very quickly, and I think that the inn has now taken down the policy. But there's actually another element to this story, and it sort of transitions into the next piece, which is don't respond with nasty counter reviews of the people who stayed at your place. So in the page 6 article, it goes on to explain what the innkeeper did to respond to a negative review. He said, for example, in response to a review complaining of rude treatment over a bucket of ice, the proprietor shot back, quote, "I know you guys wanted to hang out and get drunk for 2 days, and that is fine. I was really, really sorry that you showed up in the summer when it was 105 degrees. I was so, so sorry that our ice maker and fridge were not working and not accessible." I mean, besides the fact that it looks bad, it can lead actually to a counter defamation suit if you were, for example, to sue the reviewer for a bad review. There's another recent example from Fairfax, Virginia, and this all came out in February of this year. So this doesn't involve a hotel or any sort of lodging. It involves an individual who hired a contractor and apparently was not happy with the contractor's work, and so posted a negative review on Angie's List. The contractor then responded with some accusations of his own, and the two ended up suing each other for defamation about both the original posting and then the response to the posting by the contractor. And, you know, here's sort of what the jury did, and this gives you a sense, and yes, it did go all the way to a jury trial. This gives you a sense of kind of how the jury viewed these people. They found that both parties had defamed one another, so it found them both liable, but it awarded no money to either of them. So you really don't want to get into a situation like that where you end up responding to a review and then getting sued yourself because you're, you know, you're on the offensive in it. So here's some options you can do. I mean, focus your efforts on private messages to reviewers rather than responding sort of in the forum itself. Write to them separately if it's possible and say, you know, I'm really sorry to hear that you felt this way. You know, what can we do better? Or, you know, you could even try to explain the situation. And, you know, there's some anecdotes, and I unfortunately don't have any examples with me, but there's some anecdotes of people actually posting reviews to follow up on their negative reviews to say, oh, you know, after I posted my review, the hotel contacted me and they were very good about it, and I realized that some of the things that I said were incorrect, and here's what was going on, and I really appreciate that management did that. So there is an opportunity to sort of change it into a positive situation. Now, at the same time, don't just send sort of a form response to a negative review, either by posting it or by sending it directly to the poster, because otherwise that's just going to make it seem like, you know, you're worried about your image as opposed to genuinely trying to remedy a situation. And you know, they're likely just going to post that and say, so see, they don't really care. They're just sending this form. So if you're going to do it, personalize it. Another advantage is that it doesn't draw attention to the negative review. You don't have that Streisand effect problem, whereby trying to address something, you're just drawing more attention to it. And if you have a particularly difficult person and you're not sure whether it's a good idea to follow up, that might be a good time to get an attorney involved and to try to, you know, if it rises to that level, if it's important enough to you, and try to sort of work to craft whatever message you want to send, keeping in mind that, you know, crazy people tend to be crazy litigants, and you need to protect yourself while at the same time defending your business against a bad review. And just keep in mind that your correspondence itself might be posted. That happens all the time. There's a recent example involving Amazon and a negative review of a what do you call it, wireless router, where this company actually sent a nasty cease and desist letter telling them to take down their review, and then of course the reviewer posted it, and then there was this outcry against the company, especially given that they sell, you know, high-end Wi-Fi equipment, you're already dealing with an internet-savvy crowd that's already going to be posting a lot, and so they just got obliterated, and Amazon actually ended up canceling their vendor store through Amazon. So anyway, be careful. Anything you write might be posted. So another thing that you might do is, on one hand, as I said, you might have more success keeping things, communicating directly with the user. But on the other hand, responding, at least according to one survey that TripAdvisor conducted, can be really good. So according to this study, which was conducted in September of this year, TripAdvisor said that factors that drive the most traveler engagement on hotel or B&B pages, and this is ranked by level of impact, at least on TripAdvisor. So number 1, number of photos. 2, total number of reviews. 3, management responses in the past year. And 4, the number of reviews in the past year. And then they sort of broke this out a little bit more because I guess they, keeping in mind the bias of TripAdvisor, right? They want more buy-in to their product, and so they're going to encourage both sides to post more. So, take this with a grain of salt. But here's what they say. The study shows that taking part in conversation is also beneficial to properties. The more reviews the property's management responds to, the higher the average review rating, meaning, the star rating. The level of engagement from travelers also increases with the presence of management responses. Hotels and B&Bs that have responded to at least one review see 17% more engagement from travelers, compared to those with no management responses. Properties that respond to reviews at least 13% of the time see a 21% boost in engagement compared to those that do. So here's the average rating in the 25 most reviewed cities versus management response. So for a 0% response rate by management, it's a 3.81 average review rating. For a 5 to 40% response rate, you get a 4.04 average review rating. For 40% to 65%, you get 4.05 average review rating. And a 65% plus response rate, you get 4.15. So at least according to them, in their 25 largest markets, responses from management to reviews are beneficial to the property. And it sort of shows that you take the complaints seriously and that you sort of care about the well-being of your guests. And also, if you're going to respond publicly, say sort of what your investigation of their complaint showed. Don't say, no, you're wrong, here's what really happened, because that tends to get more into the defamation zone that this contractor in Fairfax ran into. And I didn't share the full story, but basically he started making very specific factual allegations about the woman who had hired him and how she had cheated him out of money and things like that. So if you just say, thanks for your review, we investigated it, here is what we found. That's a very sort of neutral factual statement rather than saying you were wrong, here's what really happened when you were there. It has a very different tone to it and different implications for a defamation claim. Also, encourage positive reviews. It dilutes the negative reviews. Since, according to Nielsen and TripAdvisor anyway, the number of reviews itself is helpful, then, it's good to encourage positive ones. Try being in touch with some of your trustworthy positive reviewers or regular customers and asking them to post. And just remember, again, that providing any kind of consideration, meaning discounts or anything like that, for positive reviews or encouraging the takedown of negative reviews can get you in trouble. But encouraging reviews, period, does not necessarily. So just keep that in mind. Beware of fake reviews. So, for example, if a review just discusses competitors a lot, then most likely it's someone who's affiliated with that competitor. And at least with TripAdvisor, they're actually reasonably good from what I've heard, although some of you might have had different experiences, that they're reasonably good at taking down what clearly appear to be fake reviews, either reviews that that clearly indicate that the person didn't go and they're just being a jerk, or that they're actually trying to sabotage another business because they're affiliated with a competitor. Also look for language that doesn't quite work, that can suggest that someone's being asked to write a review and they're really not familiar with the territory or even necessarily with the language. See if they're referring to other properties. And if they don't discuss any specifics about your property, that could indicate that they actually didn't go and they're just writing something. And finally, there's nothing that says you can't educate audiences about, how to spot a review that might not be real. Maybe for those of you who are part of trade organizations or anything like that, that might be something to address sort of as a group, raising awareness of some sort of basic literacy of how to read an online review and know what to believe and what not to believe. But if you are considering legal action, here are some tips. Just assume everything you write is going to be posted, as I said. Keep your letters simple, to the point and factual. Present enough facts to show that they really don't have a case, but also make it boring enough that they're not going to post it online because they're just not going to get anything out of it. And I strongly suggest, obviously it's in my own interest to suggest this, but I think it's true. Get an attorney involved at that point, rather than sending it on your own and potentially having to clean up the mess later. It's it's being proactive. If you're going to go down the road of really pursuing this poster or pursuing removal of the posting, then it's better to just get an attorney involved at the outset, because maybe it'll save you down the road. As we learned from the Ashley Inn case, excuse me, not the Ashley Inn case, the Dancing Deer Mountain case, gather as much evidence as you can, because if you do file a complaint, you're going to want to put all that information up front to prevent an anti-SLAPP motion, and then along the same lines, make sure your attorney understands anti-SLAPP laws, assuming you're dealing with a state that has them. And if you just Google, anti-SLAPP law and the name of whatever state you're interested in, that could tell you that, although you have to keep in mind, if you're suing someone in another state, that state's law might apply. It's because we have 50 different sets of laws plus, territories and everything like that, it can get complicated as to what state's law applies and, whether federal law might apply in some situations. Finally, with respect to sales of property, there are some additional concerns about, I'm only going to touch on this a little bit, about reviews of the property or things things that people might say about the setting or the location or practices in the past, or even sort of the size of the lot or the use to which it can be put. I mean, trust me, this might sound weird, but this comes up. You'll have a neighbor who is upset at the owner or doesn't want a new structure to be built there or something like that, and so they'll start making statements to prospective buyers or their agents saying like, oh yeah, this, well, that they can't put a second story on that, right? Or say, well, the lot line is really here, right? So that's potentially slander of title or other kinds of defamation, and that can happen online also. And those are potentially actionable, especially if they're going to sabotage a sale. You have to be careful, though, if what the person's doing is complaining to a regulatory agency. It kind of goes back to what I was saying before. The principle that you can't sue someone for defamation based on what they say in court, that also applies to what they might say to a regulatory agency. So if they're going to, if they want to try to mess up your sale by filing a complaint with an environmental board or a planning commission or something like that. There's not much you can do at that moment to stop it. If it's in bad faith, then there might be something you can do subsequently. It might be abusive process. It might be some other tort. But in terms of stopping them from speaking, there's not much you can do. However, if what they're doing is posting a review of your property, then you might be able to do something about it if it's false. But keep in mind all the other things we've talked about, which is if someone's talking about a matter of public concern, like, you know, you have a significant piece of property in a small community and they're writing about it. I mean, that could be considered an issue of public concern because it's a place that people know. It has a significant impact on the community. Then a heightened standard might apply. You also have to be careful of the particular other issues that relate to the topic of what they're saying. So, for example, there's a case in California decided a few years ago called Cross v. Cooper, where I think it was, well, someone was trying to sell a house, and there was sort of a vindictive neighbor who told, no, actually, I'm sorry. The situation was there was someone who was renting. There was a tenant in this person's house. The landlord was trying to sell the house. The tenant really didn't want it to be sold and wanted to be let out of rent for you know, several months, and the landlord said, no, I'm not going to do that, but I'm still selling the house. So the tenant was angry. So the tenant was telling people, you know, there's a registered sex offender, like, you know, right across the street. And according to the landlord, that prevented the sale. You know, a couple of potential buyers backed out because of that. And the court said, you know, that's commentary on an issue of public concern, and just because, you know, the safety of children and things like that is an issue that people care about in their communities, and you're going to have to show that they knew it was false. So when it comes to sort of a discussion of public concern as it relates to properties, that can come into play as well. So that's it for my prepared presentation. If anyone has any questions, please let me know.
Cliff, it's Brant. One question was, you were talking about filing a suit. Is the suit filed where, in this case, you know, it's a hotel, where the hotel is located, or in Prescott, Arizona, where the person was from?
Oh, so we're talking about the Ashley N case?
Right.
Okay. So that gets a little bit complicated when you're talking about the internet because on one hand, you know, and it also sort of depends on state law a little bit, but in Oregon anyway, you can sue where the damaged party is, so long as someone has, you know, can legitimately be brought into court there and can expect to be brought into court there. So, for example, if this person traveled to Oregon, stayed there, and then left a review that was, you know, directed at the hotel, which is located in Oregon, then under those circumstances, that person reasonably could anticipate being sued in Oregon for what they did. And that's just kind of like there's a baseline standard under the 14th Amendment to the Federal Constitution that says there have to be circumstances suggesting that you would expect to be what they call hailed into court in the jurisdiction. So the answer to the question is, at least in Oregon, you can sue where the property is located. That's also true in California, so long as it doesn't violate that principle, that it has to be a reasonable expectation someone would have to actually be sued there.
How can someone remove a review from? Is there a way to get that done through TripAdvisor or Velp or any of these sites?
Yeah, so there's a process, and I guess I should have put the link on the in the slides. But if you look at the TripAdvisor site, there are various ways of contacting them, and if it's a situation, you know, if it's a legitimate dispute, you know, the guest says one thing, the management says another, they're not necessarily going to get involved. But if it's just nasty, or if it appears to be entirely fake, or it appears to be a competitor, then there is a process by which you can have it taken down, and I've heard that they're pretty good about it, at least TripAdvisor is. I've heard Yelp is not good at all about this. And I'm actually, the advantage of a webinar is I can go to their website while we're talking. But unfortunately, I'm not finding this. I'm sure if you go to like the Contact Us or something like that. There's also a help center that probably, so if you go to Help Center, which is located at the very bottom, there's all kinds of policies, guidelines, are you an owner or representative, respond to a review, things like that. It may be that they require you to actually like sign up with TripAdvisor in order to, quote, manage your listing. That's how they get you. They,
Right.
get you to buy in order to manage what people say. I mean, people, just give you an example that happens to lawyers all the time. We have all these fake review sites where they're like, oh, Cliff, you only have a review of, 8 out of 10 or 7 out of 10. You should pay $24 a month so you can manage what people think about you. And it's like, thank you. I didn't really ask for that review, but that's, it's sort of the same thing. But I guess if you want to play, you have to become a part of it. Unfortunately, it's kind of the way it works.
Okay. I don't see any other questions. I want to thank you, Cliff, for joining us today.
Thank you.
I appreciate your time, and folks can come online to hbihotels.com to review this webinar again and get your contact information if they desire to get more details from you. To the audience, I want to ask you to rate today's webcast by clicking on the rate button, which is found on the gray bar located at the top of the webcast player. We'd like to hear your feedback. You can download this PDF list of today's featured hotel listings, plus a selection of additional hotel investment assets listed by HBI broker members under the attachments button on the top of the webcast player.
And I promise not to sue you for your online review.
Yeah, there you go. I don't think this one becomes online. Maybe it does. I think it's just central to us. As a reminder, this and previous Hotel Investor Marketplace webcasts are available on demand, viewing via the online at the hbihotels.com. HBI serves annually as a supporter of the ALIS conference, and we want to let you know that we'll be participating at the ALIS event this year in Los Angeles, January 26th to 28th. If you are attending, please look us up. We hope you enjoyed today's webinar, and please have a great day. Thank you.